We can start, ma'am.
Yes. Hello, students. Hello. Yeah.
Hello, ma'am.
Hello. Yeah. So today we are going to deal with the compulsory license topic. So can anyone tell me that have you heard about compulsory license before this one? Before this lecture?
Now we understand compulsory license is a license given to people when they claim that the invention or the product is not affordable and is the for the public on emergency conditions.
Okay. So today I am going to tell about the compulsory license and what actually is a compulsory license. Okay. And the provisions related to the compulsory licenses. So let's start. What is compulsory license? This is a non-exclusive and non-assignable license, and which is issued by the government of India. Okay. And it is issued to the interested person. If the interested person give the any type of application to the controller related to the compulsory license, if they want the compulsory license of XYZ patent, then this license is provided by the government of India to that person. But there are so many reasons which are need to be detected, that is it reasonable to give the compulsory license to that person or not. Also, it is checked that the invention is worked in the territory of India at the fullest possible extent. Okay. If it is not possible that the patent is worked in the India, or it is not totally worked or totally helpful for the people in India, then the government or the controller can grant the compulsory license to the interested person. Okay. So it is a non-exclusive. As you know that the patent, it is an exclusive right which is granted to that patentee or that applicant. On that basis, if the patent is granted to that person, then no one can use the patent without his or her permission. Okay. So that is called as an exclusive right. So if the compulsory license is non-exclusive, what is the meaning of non-exclusive license?
It means it can be taken back.
Yeah, it can be taken back, or it can be given to anyone without the permission of that patentee. Okay. So it will not exclude the others to use that invention. Okay. That is the non-exclusive license. And the compulsory license with non-exclusivity, it is also non-assignable. So what do you mean by non-assignable? Can you define? Anyone can define non-assignable?
Once we get a compulsory license, we cannot assign to anybody.
Okay. So non-assignable means if the compulsory license is given to interested party, okay, by the controller, then that interested party cannot give the same license to the another party. So in that way, it is a non-assignable license. Okay.
Exactly. Yes.
Yeah. So compulsory license is a non-exclusive and non-assignable license issued by Government of India to any interested person, and when it is given after the 3 years from the date of the grant. Okay. So within 3 years, what will going to happen? They give the time, that is the time limit for that patentee, okay, to perform that invention or to work that invention in the territory of India, or work that patent in the manner that it is beneficial to the people of India. Okay. Suppose there is one patent related to a drug, okay, which can cure cancer. Okay. Suppose that drug is there, and if it is not possible for that patentee to transfer that drug in the affordable prices in the market. If it is not possible for that person, then any interested person can apply for the compulsory license. Okay, so there are different grounds on which we can apply for the, any interested person can apply for the compulsory license provision. Okay.
Madam, here one question, madam.
Yes.
This compulsory license, after getting by the interested person, does he have to pay the renewal fees to the patent office?
No, when it comes to the compulsory license, now suppose the X person having that patent and the controller giving the compulsory license to the another person, ABC. Okay, so the royalty is decided by the controller.
Okay.
Yeah.
So
Next,
ma'am, just one query, ma'am, here.
yeah.
So if we understand correctly, the person who got the patent, if he is not able to commercialize a product
Yeah.
on that patent, then only the commercialization, then only the compulsory license will come into picture, right? It's not mandatory that all the patents which are granted after 3 years, if an interested person asks, we have to give definitely the patent to the other interested person, right?
Yes, actually, what happens now? There are different types of provisions. So, in detail, we are looking
Sure. Okay.
that. Yeah.
Okay,
So
if we are going to cover
now
in
we.
upcoming slides, then it's fine.
Yes. It is going to cover in upcoming slides. Okay.
I think what Muralidharan sir wanted to ask was if that license, like compulsory licensing, is allotted to any interested person, then what happens to that patent? Do we need to like pay the renewal fee to keep that patent alive till 20 years, like that? Am I right, Muralidharan sir?
No, that if it is exclusive license, then he has to pay the maintenance fees. If it is non-exclusive license, then the royalty will be decided while giving the compulsory license itself.
Okay, so what happens to the like payment of terminal, that yearly payment that we do?
Yearly payment has to be paid by the assignee only, right? Because the person who is taking the non-assignable license, he will not be acting as assignee. So whatever he has to pay as a royalty, and that may be either breakup or it can be in one go.
Okay.
That will be decided based on the case to case.
Okay.
Here, renewal fees, what happens to renewal?
That is what he is telling.
So Muralidharan ji, if you closely understand, okay, so assume like you have a patent, okay, I have applied for a compulsory license. So the controller will decide at the time of giving the license, that calling both the parties, and under mutual understanding they will decide the royalty, and the royalty can be paid in one go or it can be paid as multiples.
Okay.
Now the royalty covers the cost of patent, maintenance, everything that will be calculated by the person who owns the patent.
Yes.
Okay. And if you have come up with one number, the controller also has to agree, and you both will tell me the number. And if I am ready to pay that number, then only you will give me the non-exclusive license.
That is between the party and the patentee. What about the patent office?
No, that's what I'm saying, right? Controller will be definitely in the picture. We cannot avoid the controller, and we cannot decide in
the royalty agreement. Now there are different provisions, so
yes.
It is covered in that one, in that agreement. Okay. So next point is license holder gets rights of producing or carrying out the patented product or process without the consent of patentee. What that is, I am talking about non-exclusivity. That is non-exclusive license. Okay. So license holder, that is after the compulsory licensing is done, okay, and which is given to that license holder, gets the right. What he gets, that is the right of producing or carrying out the patented product or process. If the process patent is there, then process. If the product patent is there, then product. Then he can work on that patent or produce that patent and he can easily sell that product or work on that process without the consent of patentee. Okay, so that is called as a compulsory licensing. That is the rights given to the another party for the benefit of human beings. Okay. Next one is, it is a safeguard against the potential abuse of the monopoly by patentees. Okay, so as you know that potential abuse will comes with the monopoly, as we know that if in the market only one product is there, okay, and if the supply is not there and the demand is there, and who is supplying that product which is having the monopoly over that technology, okay, then that only one person can produce and sell that product in the market. If that one person which is having that patent is not able or which is not capable to produce and sell it to the market, then what will going to happen? The product, that means the fulfillment of that patent will not possible. What is the benefit of IP? Can anyone tell me what is the benefits of patents or IP or R&D, research and development? It is generally done for the benefit of the
Public.
people. Yes, yeah. In the bigger way, what we can say that it is for the it is beneficial for the public at large. Okay, if the monopoly is there and the patentee is not able to produce that product, or he is not capable, then what will going to happen? Or if he is able but he is not producing, or if the prices are not affordable,
Yeah.
then the abuse will done. Yes, and that's why the compulsory license will come into the game. Okay.
An individual is a patentee, then he may not be affording to produce in a large scale. So compulsory license will come into play.
Yeah, compulsory license will come into play. Then another person want that license, if the patentee is not able to produce or provide that patent or work that patent in the territory of India, then any interested party can apply for the compulsory license. Okay, so there are another things are there also, so we can see in the another slides. Okay, let's see that section for compulsory license in India, Indian Patent Act. So which are these section, as you know that section 84, section 85, 86, 87, 88, 89, 90, 91, 92, 93, 94. All these section from 84 to 94 deals with the compulsory license and related issues. So in that section 84, which deals with the main grounds for invoking the compulsory license. So what are the main grounds which invoke the compulsory license? Okay, so we have to see that section 84 in detail. As we know that section 92 capital A comes into the force after after Doha summit, and in 2001 it will come into the force, that is section 92 capital A. And what are the different forms related to the compulsory license? That is form 17, which is related in that section 84.1, section 91.1, 92.1 and 92A. They told about this form 17. Okay, so in this way. Okay, so so any interested person, by means of the application, he apply to the controller for the compulsory license, and with some prescribed fees can apply for grant of compulsory license. Okay, so initially what is the process? That is interested party apply to the controller, with some prescribed fees is also there for the grant of compulsory license. Okay, can anybody open the form 17?
Yeah, madam.
Please open the form 17 and look at it. So it is the application for compulsory license, and under section 84(1), 91, 92(1), and 92 capital A, and rule 96. So it will cover all these provisions. Okay, all these sections it will cover. So what is included here? The name and address and the nationality of applicant. Please open the form 17 on your desktop.
Finally, the name of the natural person who has signed is there. If it is done by entity, it is not this one natural person. Only for natural person this is applicable.
For what you are asking?
Yeah, part of the form 17, number 5. Name of the natural person who has signed is given.
Muralidharan, your sound is not coming properly. Please.
Madam, if you look at the form 17,
Yeah.
at point 5.
0.5, okay.
Name of the
natural person who has signed.
Yeah, suppose the patent for a firm it is not a natural person, right? Then it has to be the natural person or the what do you call the others?
Sir, the one who represents that company, like some representative of that company will be signing the document. There won't be any company signing that, right? So that is why it is given.
Okay. See, at point 1, name, address, and the nationality of the applicant. That is who is applied for the compulsory license. I, V, dash hereby apply for the grant of compulsory license under patent number and dated, granted to dash for which the patentee is dash on the following grounds, namely. So the grounds are also listed here in the form 17. Certified copies of the documents are to be enclosed in duplicate. Then complete address including postal code and state along the telephone and fax number. Then I will declare that the facts and matters stated herein are true to the best of my or our knowledge, information, and belief. Then in 4th point, to be signed by the applicant or by his authorized registered patent agent. The details of documentary evidence in support of my or our interest and in the grounds stated above are given below. So the grounds are also given in the form 17.
I'm just one query. So if we connect back to Muralidharan's query, he was asking on sorry for that. In point 5, it is mentioned only natural person. So if there is an assignee, where he may not be able to apply for that, right? Right, Muralidharan? If that is the case, it is addressed in form 4, right? Either the applicant or any concerned person of that applicant who is legally authorized to sign that will have to mention the details, right? Yeah. Okay, ma'am.
So, so that natural person is not the representative of what? I mean, I was thinking that way.
The natural person is separate when it comes to this one, right? If you are paying the fees, even while paying the fees, the natural person is considered as an separate, right? In SMA or small scale industry or startup or natural person, right?
I thought like if any educational, for example, if any educational institute is like applying for this compulsory license, then the director of that will be the natural person. Like here.
That will be decided based on the discussion in between the inventor and the institution. Okay, not all patents may go under the name of institution. If the institution is funding for that, yes, definitely the institution's director will go under the name, and the inventors will be named as the respective inventors, the other persons. But if the person is funding on his own, there could be a possibility he may or he may not assign it to the institution.
Right.
Yes.
Okay.
Right. So then
Okay.
he will be applying as a natural person. And same
Maybe
case
he's-
comes with the company comes with the organizations as well. If the organization is paying you as a salary, then your organization name will be represented as applicant and you will be inventor. If your organization is paying you, but in the invention which you are trying to file does not belong to organization in any manner, then the organization may either give you a chance to go and file on your own with your own expenses. In that case, you will be still have to file as a natural person. And the when it comes to assignment, at that time, organization may also ask you like whether to put their name or not. Because if they think that the knowledge obtained to file this particular patent in this particular area, if the knowledge was gained in the organization, then they may also come into picture.
Okay, there are different types of agreements. That is, inventor agreement is also there. What sir told me now. They told that is there is the agreement between these two parties. That is, and that agreement it is called as inventors agreement. So the terms and conditions are listed there. So on that basis, it will happen generally.
Okay,
That
madam,
is
you can
the
proceed.
The inventors agreement is between whom, ma'am?
it is between the applicant and inventors.
Oh, okay.
Yeah.
Okay.
And yes, then next point is application should describe the nature of applicant's interest and facts upon which application is based. Okay, so on which facts the application is based, we need to list that. Okay, and the nature of applicant's interest, that is what is the purpose, that is why they are applying for compulsory licensing, that is the nature of applicant's interest is also need to be listed there. Okay, so next point we will say, so have you understood about the form 17? It will cover 84.1, 91.1, 92.1 and 92A. And section 92A will come after Doha 2001. Okay. So next one is ground for invoking compulsory license, that is section 84.1. So there are different grounds which are responsible for invocation of the compulsory license. In that, the first ground is if reasonable requirements of public is not met. Okay, as I told you that if there is a drug and the patentee is not able to meet the reasonable requirements of the public, he cannot give the drug at affordable prices, or he cannot make that drug and work that drug in the territory of India, then we can say that the reasonable requirements of public is not met. Okay, that is the first ground for invoking the compulsory license. The second ground is invention not available at affordable, affordable price is another one. The reasonable requirement of public is not met. Generally, reasonable requirement in terms of what? That is
Quantity, madam. Large scale quantity.
Yes,
Yeah,
yes.
the best example could be COVID vaccine. If somebody would have got the patent, then even then he could not have met the requirements of the public in the given
Yes.
time.
Yes, yes. That is, if he cannot manufacture it in that large amount. Okay, so mass production is not possible by the patentee due to his incapacity. That is, he doesn't have that much of capacity or capital. Then that is the first ground.
He doesn't have infrastructure.
Infrastructure, even he doesn't have any capacity, means the capacity is related to the money which is invested to produce that product.
Yeah,
okay. Yes. Then the reasonable requirements are not met, na. So that is the first ground. Second one is also if he can make it in a large scale, then he can give in the affordable price. If there is under any circumstances, if it is not possible, or intentionally if he is not making it affordable prices due to the monopoly, then also this is the ground for the invocation of compulsory license. And third one is invention is not worked in the territory of India. If these two first requirement are not possible, then obviously why the invention will going to work in the territory of India. Okay, if there are some environmental situations are like in the way the patented invention is not worked properly in the India, then also that is also the ground for the invocation of compulsory license. Okay, so these three grounds are made, that is if the reasonable requirements of public is not met, second one is the invention is not possible at affordable price, and third is invention is not worked in the territory of India. So you can see in one of the case study under section 83 and 84 of the Patents Act 1970, the act or non-working of patents in India exposes a patent to compulsory licensing. Okay, that is the point, that is non-working of patents in India exposes a patent to compulsory licensing. Okay, as you know that if the invention is not worked in the territory of India, then the patent is going for the compulsory licensing. But what the court say, however, the court in India have not followed any strict line of reasoning in this regard. Okay, and each case has been decided based on its fact and circumstances. So this is the topic also. Okay, so we cannot say that always it is strictly followed, that is the if invention is not worked in the India, then it is going for the compulsory license. So it will depend upon the facts and some circumstances, and they need to study that, and after that the controller give this give that it is it invocation is possible or not. Okay.
Madam, here one question, madam.
Yes.
After getting a compulsory license, the person who got the the compulsory license make some study and make some improvements. Can he be allowed to do so?
If he is making the improvement in that patent, that is in a parent patent.
Yes, yes.
Okay, so it will firstly the controller, if he is applying for the patent, so then it is called as evergreening, na? So generally evergreening is not done, but because there are some clauses that evergreen, so evergreening should not be followed generally, actually, because the provision of compulsory license is come into force only when we want to give the benefit of that patent to the human beings. So that's, and that invention he did, it will add it to the parent invention. Okay.
Then
That
can
is
he
the
file a
kind of-
patent of addition then?
Yes, patent of addition. Yeah.
Okay.
See, based on my experience, it will also be written in the agreement.
Okay.
Because when you are applying for a compulsory license, right? So if it gets approved in the office, you will be asked, like tomorrow, if the licensee wants to do more changes to what he has got as a patent, and then he may do so. But having said that, if he has improvised to certain extent where the original patent owner cannot sell the product in market, then he can also counterattack that.
Yeah.
Here in the case,
Yeah.
the patentee is entitled for his own invention and patent.
Yes.
Right?
Yes.
Compulsory license holder make some improvements in the
Yeah.
then he has to get the approval of the original patentee.
He don't have to get the approval, but while giving the compulsory license itself, you can mention a clause that tomorrow, if the licensee becomes comes up with an advanced invention to the existing, wherein he can be a true owner of that particular product. If that is so, then he can directly sell that product with advancements, and he can also charge more for that. But the thing is, if the clause is written in such a way that whatever the invention that I am giving is him as a compulsory license, he has to work on that. Any modifications that applies to that are equally distributed in between us. This particular clause makes you safe that if he makes any advancements, then the patent owner also can use that advancement without any fee, without any royalty.
Yeah.
Okay, because I underwent this particular situation recently, because we licensed a patent from UK, and in the clause was mentioned that we can any part of the time till the end life of that particular patent, if we make any kind of advancements, the patent owner will it will be free to use that advancement without any royalty.
Correct.
Sure.
So now you can see my screen, no?
Yeah.
That is engagement agreement. Are you looking at yours? Okay.
No, grounds only display.
1 minute.
So it seems like these agreements are like playing a very important role.
Yes.
Yes, Kashmira madam.
Definitely, wherever you go, right from the start of NDA, inventor's agreement, NDA, non-disclosure, supplier agreement, everything is important.
We agree to
Only
that.
patent cannot make you stay till 20 years in market. That is for sure.
Agree to agreement.
So yeah, in any agreement, there are different types of terms, condition clauses are given. Okay, and they are prior discussed first, and then after they will come to that point that these things should be included in the agreements, and after that it will happen. Okay. So today in the first we look at that section 84.1, that is a ground for invocation of compulsory license, and there is one case study related to that section 84, that is NATCO versus Bayer. That is the landmark case where NATCO applied for the compulsory license, and NATCO is granted that compulsory license on Nexavar, and the Nexavar is nothing but a Bayer's product, that is Bayer's patent, that is Nexavar, for kidney and liver cancer. Okay. So what NATCO gives the arguments, that is the arguments given are under section 84.1a. So let's see what section 84.1a says. That is that the reasonable requirements of a public with respect to the patented invention have not been satisfied. Okay. So NATCO says that under section 84.1a, the drug was not supplied in India in the year 2008 and 2010. Only 200 bottles were supplied in 2009. So within that 3 year of span, only 200 bottles are supplied. So it means that the reasonable requirements of that public is not satisfied. And under section 84.1b, what they say, let's see the 84 section 1 and b, that the patented invention is not available to the public at a reasonably affordable price. Okay, let's see the price. So the price here is 2.8 lakhs. So for that 120 tablets for 1 month, the price of that tablet is 2.8 lakhs.
Sir, we are not seeing the screen of yours.
Okay, 1 minute. Yeah. Now you can see, na?
Yeah.
Yeah. Okay. Then we are going for the section 84. In that detail, we are looking towards one case study, which is a landmark case of NATCO versus Bayer. Okay. And the Bayer is having a patent on Nexavar, which is nothing but a kidney and liver cancer drug. Okay. And NATCO applied for the compulsory license, and he also granted that compulsory license. So what are the arguments given by the NATCO to grant the compulsory license in form 17 is that under section 84.1a, so let's see section 84.1a, this one, that is a 84 for the compulsory license, and 1a it will say that reasonable requirements of the public with respect to the patented invention have not been satisfied. That is the first argument of NATCO. Okay. Let's see the second argument, that is under section 84(1)(b). What is section 84(1)(b)? That the patented invention is not available to the public at a reasonably affordable price. Okay, so let's see what is the price of that product. The drug cost estimate for a single patient per month, that is for 120 tablets, only 2.8 lakhs rupees they charge. So it is not only for Indian people. So it is a very huge amount, and it is not possible for each and every person to cost that much of amount for 120 tablets. So under section 84(1)(b), this argument is also right. That is reasonable. The patented invention is not available to the public at reasonably affordable price. Okay. And what is the third argument? Under section 84(1)(c), they told that the drug was not manufactured in India. Okay, so it is not worked in the territory of India. 84(1)(c) says that the patented invention is not worked in the territory of India. It means it is not manufactured in India. So these are the three arguments. And on the basis of these three arguments, NATCO granted that compulsory license on Nexavar. That is the landmark case, and this is the judgment. Okay. Have you understand this?
Yes, madam. Yes, madam.
Okay. Yeah. Okay, let's see section 84, what it is say. 84 says the compulsory license in that at any time after the expiration of 3 years from the date of the grant. Okay, so from the date of the grant, the time which is counted, that is up to 3 years. At any time after the expiration of the 3 years from the date of the grant of patent, any person interested may make an application to the controller. So with form 17, he can make that application for the grant of compulsory license on patent on any of the following grounds. So there are these ABC 3 grounds, that is that the reasonable requirements of the public with respect to the patented invention have not been satisfied. Okay, so they are not able to manufacture that patent in mass scale. Then second one, that the patented invention is not available to the public at reasonably affordable price. If it is not mass production, then obviously it is not affordable. And third one is that the patented invention is not worked in the territory of India. So they are not able to work to produce that patent in India, and they are making that out of India. Okay. And due to that also the price will go higher. Okay, next one, consideration by the controller, that is section 84(6). So what are the different types of consideration followed by that controller before granting the compulsory license? So what he look towards, that is the nature of the invention, the nature of that invention, which type of invention it is, and second, the ability of the applicant. Okay, third is the capacity of the applicant, and fourth is the efforts of that applicant to obtain the license. Okay, if anyone applied for the compulsory license, so in this case we can say that is the applicant here. Okay, so it is not the patent applicant, it is the compulsory license applicant. So what controller see, that is what is the nature of invention for which the application is obtained. Okay, second one, the ability of the applicant, is that applicant is able to make that invention work in India or not. Third one is the capacity of the applicant, that is he is having that much of capacity or that much of infrastructure, okay, that much of money to make that invention work in the India, or he can do all the things related to mass production or to supply that invention in the market available prices, in affordable prices. And last one is the efforts of applicant to obtain a license. So if the applicant wanted really genuinely for the compulsory license or not, is then it is also one type of consideration Okay, so these are the four important consideration under section 84(6), that is the nature of the invention, ability of the applicant. Okay. Then capacity of the applicant. So ability in terms of the how brilliant that applicant is, or how capability in terms of the money, and ability in terms of the other aspects, that is in terms of we can say that brilliancy of that applicant,
Madam,
and the efforts of the applicant.
question,
If the applicant is genuine and he also want to make that patent work in the India, and he can do all the things related to that, then that is also one type of consideration. Okay.
here one question, madam.
Yes.
Affordable price. How is affordable price arrived? And who decides the affordable price?
Okay. Okay. In this case, in Natco and Bear, you can see now. So if the prices as per the Indian market for 120 tablets, 2.8 lakhs approximate cost they charged, then is this affordable for Indian market? For Scandinavian, it is I think maybe affordable, but for Indian market, it is
Indian
not
market,
affordable.
what is the affordable price, madam?
Affordable price means the affordable for any person, that is poor persons. It is affordable for poor persons. He can also make.
Or
Yes.
is it within 1,000 rupees? Or what is the?
It is within 5,000 and 10,000. It is okay, but it is in lakhs and it is in crores. Then how any person in underdeveloped or developing country cannot afford, no?
How the price is determined, ma'am? Like if it is a drug, then the components of the drugs, we take it separately. That calcium is like having a price of 80 rupees per kg, and this that way it goes, or like how it is determined?
Actually,
is there any
all
body?
these
Is there
all
any?
these no, all these prices are determined by means of the valuation. So after patent valuation, if there is XYZ patent and ABC patent, they are two similar patents. Okay. And this in that case, if the valuation is done, that is the market evaluation is done for these two patents, then suppose XYZ patent charges 2.8 lakhs for 120 tablets, and ABC patent will charge only suppose minimum amount we can take, that is 50,000 for 120 tablets, and 1 minute. And if these both patents having the same effect, okay, the efficacy of both the drugs is same, then the evaluation is done, and on the basis of that evaluation, the prices are determined. Okay, that is the another field actually. And
in case if there are no similar patents, just one patent, there is no comparable patent, then in that case, who determines, which is the authority that determines the price of all the components and the drugs?
The applicant, the producer is determining that one. No? That's why the compulsory license will come into force if there is only one producer and supplier, and the demand is more. So in that case, the demand and supply will not match. So the monopoly will create what we can say.
See, for any given product, the marketing department of that particular product organization will decide the per piece rate. Okay. And if your competitor also will have their own market department, right? And if they say that whatever you are quoting is not under affordable price, then they can go and apply for this compulsory license.
Yes.
Because
So
because you are patent owner, you cannot claim 3 times of your investment under each project, right? By selling
Yeah,
each product. See, you are the first person. The moment you got a patent, you are the first person to invent something, and you have manufactured that product, and you are now going into market. Okay, so you need to come up with an affordable price, and you cannot quote something which is not affordable by anyone, or else you cannot sell a product in India at least to only high-rise people. Okay, it should be like everyone should be able to take the benefit of that particular product. So when it comes to government, everyone should be able to take the benefit of that particular thing. Now, when you are quoting something, you should either be coming up with 3 different products, wherein high level, middle level, and low level, or else you can also think of the waste. Otherwise, definitely you will face the compulsory license situation. And this, all the marketing department already knows that, and that is where they fix out the price based on the margin. They will not cross that margins. Otherwise, they will see definitely there could be a compulsory license issue raised on in front.
Right. Okay.
So,
yes.
Shashi, here there is 3 situations. One is the inventor in his own country makes the product affordable in that country. Okay, may not be in India.
See, the
And
best.
second thing, the cost of making in India may be higher for him and non-profitable. Okay.
Two things, Muralidharan. When we are speaking about compulsory license, we should stick to India. Okay, because since this particular clause can be applied only in Indian market, right?
Agreed.
So now you can sell your product in number of countries, and we are not thinking about the price in Australia or US or somewhere. But definitely, when you are quoting a price in India, definitely you need to consider this compulsory license may arise tomorrow. If you guys are any of you guys are watching Shark Tank, you will get to know how they will quote the price. There is some Shark Tank episodes that are coming in Sony, right?
Right.
I think if anyone have watched that one, they will ask what is the per piece rate. Okay,
Yes.
and what is your manufacturing cost and what is your selling cost. If somebody says that I am manufacturing a product for 150 rupees and I'm going into the market with a margin of 700 rupees, so altogether he is claiming 300 to 400 times of his rate, right? Which is not going up to market strategy. And even if he holds a patent, tomorrow he will face the compulsory license. And that is why they ask them, before putting the shares, before buying the shares, one has to also see whether he is going into the market as per the market strategy. Otherwise, the sharks will definitely tell them, like, you don't know about market. You need to go and again look into your market strategy.
No, that is regarding capital provision and other aspects associated with that. But what we are talking here is the opportunity and thinking in India. Why these two things are not there? Because
not only capital, they will ask per piece rate also. If you clearly observe, per piece rate.
No. The person who is going to shell out his capital will look into every.
Yes, definitely, right?
Yeah. Here, this Bayer is making product elsewhere. Okay. For reasons, various reasons known to him. For example, the raw materials may not be available in India. Not profitable for India.
Muralidharan, your voice is not clear. But if I understood it correctly, here the Bayer, whatever they have put the cost, right? So that is based on the other country's cost, right?
Yes.
Maybe in that country that was the price, but they want to enter into India also with the same price. Okay, and that is where in that country there was if there is no compulsory license law, they are good to go with any price what they want. But while entering India, they should have thought of this compulsory license issue, and then they could have reduced the price. If not, they definitely have to face it, and they faced it, and they have to provide the compulsory license to NATCO. So in the similar way, if you are manufacturing a product, you can quote any number in anywhere out of the India. But while pricing for that product in India, you need to definitely consider this compulsory license thing. Otherwise, you may have to face it in future.
Sir, I
And
have
that-
one more scenario for this. Suppose, just I'm giving the example. I noticed that, and I got to know the one of the area of the electric vehicle charging device. Third party and the patent grant owner is selling that product in the market 2.5 or 3 lakh rupees. Okay. And I come across to know it's a very high price, and it is not affordable to the countries like India, because the electric vehicle is booming and it is very important to use the technology in the India. Can I apply for a compulsory license? What the price which the competitor or the patent holder is making is 3.5 lakh rupees. Can I ask the controller, which is very high price and it's not affordable to India, and it's very high demanded and a boom technology? Can I sell this product, which is their quoting is a 3 lakh rupee? Can I give the product to 50,000 rupees? In that case, the controller will give the compulsory license to the licensee.
You should be person interested, first thing. Okay. So you know the person interested definition, right?
Yeah.
So you should be person interested, and you should be able to compete the product with similar quality, similar efficiency, everything. No compromise on quality or quantity or material or life, reliability.
All that are I'm meeting the requirements, sir. I'm not
And you
compromising
are
any
also
quality.
quoting that your price is half of the
Correct.
other person.
Yes,
then
yes.
you're good to go and apply for that.
Okay.
Thank you.
Main
Okay,
thing what they do is like no compromising on quality, no compromising on reliability, life of the product and quality of the product.
Even the patent is given that time to produce that in affordable prices, and after, if it is not possible for the patentee, then it is assigned.
Yes.
Okay.
Yeah, that's my first question I asked, right? Like if a patentee got a patent and he is not able to commercialize the product on that, then the oppositions whoever the competitors are there, they can watch that patent for 3 years, and in these 3 years he has not launched the product, then also they can file for compulsory license.
Yes.
Agreed.
Yeah. Okay. Okay.
Thanks for the fruitful discussion.
Okay, next one, it is a section 84(6) in Patents Act 1970. Let's see what it will say. That is, in consideration, the application filed under this section, the controller shall take into account in that first one, the nature of the invention, the time which has elapsed since the sealing of the patent, and the measures already taken by the patentee or any licensee to make full use of the invention. That is the first condition, the nature of the invention, the time which has elapsed since the sealing of the patent, that is after the patent is granted, and the measures already taken by the patentee. What are the different types of measures taken by the patentee to commercialize that patent, or any licensee to make full use of the invention. So it is when we are studied the consideration, and the consideration are based on the section 84(6). So in that the nature of the invention is there. Next one is the ability of the applicant to work the invention to the public advantage. Okay, so the ability of that applicant is also checked. The capacity of the applicant to undertake the risk in providing capital and working the invention if the application were granted, that is the capacity of applicant is also checked. And fourth one, as to whether the applicant has made efforts to obtain the license from the patentee on the reasonable terms and conditions, and such efforts have not been successful within a reasonable period as the controller may deem fit. Okay, if the applicant is applied for the license, okay, in the fourth case, this is important. As whether the applicant has made efforts to obtain the license from the patentee on reasonable terms and conditions. So terms or conditions listed shall be reasonable, and such efforts have not been successful. If the efforts are not successful, it means the applicant is applied, but the patentee is not responded. Okay, it means the such efforts have not been successful within a reasonable period, that is within a 6-month time, or within the time given by the controller. If it is not possible to make that type of agreement, then what the controller will do, as the controller may deem fit, what he will do, provided that this clause shall not be applicable in the case of national emergency or others. So okay. This clause is not applicable. So this fourth clause is applicable for the case of national emergency or other circumstances of extreme urgency or commercial use, or on establishment of a ground of anti-competitive practices adopted by the patentee, but shall not be required to take into account matters subsequent to the making of application. So what is the explanation? For the purpose of clause 4, reasonable period shall be construed as a period not ordinarily exceeded a period of 6 months. Okay, so within a 6 month, this will happen. Okay, if it will not happen within the reasonable period, then the license is given to that applicant. Okay, so the one case study is also related to this one. So the case study related to BDR Pharmaceuticals versus BMS. So BDR Pharma is applied for the grant of compulsory license for dasatinib. Okay, so dasatinib is a drug manufactured by a BMS drug. So the patent of this drug is with BMS, which is nothing but the drug for blood cancer. Okay, so the plea was made under section 84(1)(b). What is section 84(1)(b)? So section 84(1)(b) is that the patented invention is not available to the public at a reasonably affordable price. So price issue is there. So the plea was made under 84(1)(b) as a BMS sold a month drug for 1.65 lakhs rupees. Okay, so this is not a affordable price. The grant was rejected by controller because then as the drug is not sold on affordable price, then even the grant was rejected. So why the grant was rejected? We can see that the grant was rejected by the controller because the applicant didn't comply with section 8464. So what 8464 says, that as to whole the applicant has made efforts. So the applicant is applied for compulsory licensing. They made all the efforts. Okay, but patentee is not responded. Okay, so that's why the grant was rejected by the controller, because the applicant didn't comply with the section 8464. Why he is not compliant? The applicant initially requested for voluntary license from BMS. So he applied directly to the BMS for voluntary license. So he can also any person or any organization can apply for the voluntary license to that patentee. So initially BDR Pharmaceuticals applied for the voluntary license for this drug, okay, which is the drug of BMS. But BMS responded with series of questions. The communication will occur in this way. The applicant applied for voluntary licensing. After that, the BMS responded with some questions, okay, which were not replied by that applicant. So which is not replied by BDR Pharmaceuticals. Okay, this conversation was made by BMS within 6 months from the date of receipt of initial request by BDR. Okay, so it will not happen within 6 months, and that's why the compulsory licensing, which is applied by BDR Pharmaceuticals, applied for this compulsory license, which it is not granted to BDR Pharma. Okay, so this clause is also important. That is section 8464. as to whether the applicant has made efforts to obtain a license from the patentee on reasonable terms and conditions, and such efforts have not been successful within a reasonable period as the controller may deem fit. Okay, so have you understand this case study?
Yeah, madam.
Okay, so what you studied from this one?
Actually, there are two drug companies. One drug manufactures drug for a cure to blood cancer, and another pharma company wanted to from this company, and that license arrangements did not work out. Based on that, that pharma company tried to get a compulsory license because the drug of price was not affordable. But controller found that the license was not done in a proper way, so he rejected the grant.
Okay, yeah. And also the all the conversation will not happen within the 6 months, and that's why it will not happen. Okay, so it is rejected. So next slide, that is the terms and condition of compulsory license under section 90. So let's see section 90, what it will see. The terms and condition of compulsory licenses. In that first one, in settling the terms and condition of license under section 84, the controller shall endeavor to secure what controller do shall endeavor to secure. First one, that the royalty and other remuneration. So with royalty, other remuneration are also set by the controller, if any, reserved to the patentee or other person beneficially entitled to the patent, in reasonable, having regard to the nature of the invention, the expenditure incurred by the patentee in making the invention or in developing it and obtaining a patent and keeping it in force, and other relevant factors. Okay, so all the necessary fees, which is the remunerations is there. Okay, so they are covered under the terms and condition of compulsory licenses. Okay, in this first one, in settling the terms and condition of license under section 84, the controller shall endeavor to secure. So it is all the responsibility of the controller to secure all these payment issues, that is royalty and remunerations. Okay, in that what they are saying, that royalty or the remuneration, if any, reserved to the patentee or other person beneficially entitled to the patent. Other persons mean patentee if there some share is given to the inventor also. So other persons are there, or licensee, other licenses are there. Is reasonable, having regard to the nature of the invention, the expenditure incurred by the patentee in making the invention, that is all the expenditures are also there covered. That I told you already that the inventor's agreement is there now. So if the expenditure is done by only the applicant, then it is also taken in that way. If the expenditure is done by applicant and inventors, so which type of expenditure is there, so it is also written in that agreement. Making the invention or in developing it and obtaining a patent, so patent fees or other charges, attorney charges, is also written there, and keeping it in force and other relevant factors. Okay, so I will show you one in inventor's agreement. 1 minute. So in this way, the inventory agreement is done. So in that, suppose you can see that this one, no?
No, I'm still here on presentation.
Okay, now.
Yes.
Yeah, okay. Okay, look at this. This is the inventors agreement. So it is between applicant and inventors. So clauses are inserted here as per shall be shared and settled as per the class 2 and 3. So ownership of IP is given. Expenses sharing, it is also given here. Revenue sharing is also given. And the signature of inventor or applicants. So in this way, the agreement is still on. It is pasted on the bond papers. Okay.
Ma'am, is there any possibility that like in questions we can be asked to like frame such inventor agreements or compulsory licenses agreements? Can they ask us
No. That is the different field actually. So
Okay.
in that much of detail, they will not ask.
Okay.
They just want your conceptual clarity only.
Mhm.
Related to Patent Act, they want the conceptual clarity. In more detail, they will not, because the topic is very huge. Patents is not only one. It is the field is very bigger actually, IP field. So.
See, we need to restrict ourselves as an examiners, not advocates. Okay, so this is the job of a corporate lawyer. Okay,
Right.
all the agreements and everything, because you definitely need a law degree for any kind of agreement to be executed. If you are holding a bachelor's law or a master's law along with patent agent, yes, you can do both. But if you are you are a science background person and looking for only patent agent exam, then yes, you can also omit the agreements, because it's the job of corporate lawyer.
All these agreements and the NDAs directed from the legal team from the corporate.
Yes.
Okay. Okay. So you understood that, na? In section 19, what is included? That is the royalty and other remunerations, which is the responsibility of the controller to fix that one. Okay. And what is included? That is the nature of the invention, expenditure incurred by the patentee to make that invention, or the fees of that is what we can say, expenditure incurred to get obtained a patent and keeping it in the force. That is the other fees are also included, and other relevant factors. Okay, so all these things are included in that agreement. Second one, that the patented invention is worked to the fullest extent by the person to whom the license is granted and with reasonable profit to him. Okay. So, so what do you understand by this one? The patented invention is worked to the fullest extent. It means it is worked in the territory of India in the fullest extent, and with the affordable prices. Anyone can buy that in that product. Okay. By the person. By the person means by applicant or by patent. By that person to whom the license is granted. It means it is the applicant of the compulsory licensing. So the applicant who applied for the compulsory licensing shall work that patent with fullest extent as possible with his efforts. Okay. That the patent, third one is that the patented article are made available to the public at reasonably affordable prices. So price comes in this way. So these two things are different. To work to the fullest extent by the person means the mass production, and it should be available at reasonably affordable price. Okay. So after mass production, it will happen. And fourth one is that the license granted in non-exclusive license. I already told you that it is non-exclusive. Exclusive. It means they will not exclude others to use it. Okay. Fifth is that the right of the licensee is non-assignable, it is non-transferable. Okay, so if the license is granted to that person, then he cannot assign that license to the another person. It is non-transferable. And sixth one, that the license is for the balanced term of patent. That is, what is the balanced term of patent?
So the remaining, like after grant 3 years plus the remaining.
After the remaining.
Balanced term, yes, after
remaining term of patent.
Yes, unless a shorter term is consistent with public interest. Okay. Next one, that the license is granted with the predominant purpose of supply in the Indian market, and that the license may also export the patented product if need be in accordance with the provisions of subclause 3 of clause A of section 7 of section 84. Okay. Anyone having the law patent act with them?
Yes, madam.
Can you read that section 84 in that subsection 7 clause A in that subsection 3?
Yeah. For section 84, subsection 7.
7 clause A.
Clause A, clause 3.
And subsection 3.
A market for export of the patent article manufactured in India is not being supplied or developed. Or the fourth one is
Murlidharan, please stop. Your voice is breaking actually. Anybody who can?
Okay, section 84 7A3 says that a market for export of the patented article manufactured in India is not being supplied or developed.
Okay. So what it means?
Means where it is necessary, where this product is manufactured out of India, can make and export it to that country.
Your voice is breaking, sir.
So what they say that the license may also export the patented product if needed and be in accordance with the provisions of this subsection of the section 84. Okay. That the license is granted with a predominant purpose of supply in the Indian market, and that the license may also export. So the patented product, we can also export that patented product which is made by compulsory licensing. Okay. Next one, that in the case of semiconductor technology, the license granted is to work the invention for public non-commercial use. So can anyone tell me that what is the non-commercial use, public non-commercial?
For educational purposes.
Yes. So for the case of specifically why they are giving the semiconductor technology? Is anyone related to the electronics and telecommunications? Hello?
Madam, in the case of traffic regulations,
in case of semiconductor technology, what will happen? Within 3 months, 6 months, or within a year, they will upgrade that technology, right?
Yeah.
So in that case, that in the case of semiconductor technology, the license granted is to work the invention for public non-commercial use. If the technology is drastically changing, and in that case, if they are granting the licenses, so what will going to happen to that licenses?
License will become obsolete.
Yes. So that's why they are taking that clause, that public non-commercial use. License granted is to work the invention for public non-commercial use for the purpose of education they can use. Okay. Next, that in the case of license is granted to remedy a practical, that in the case of license is granted to remedy a practice determined after judicial or administrative process to be anti-competitive, the license shall be permitted to export the product, a patented product, if needed. Okay. So anti-competitive practices, as you know about anti-competitive practices, which are the different types of practices which are anti-competitive. Do you know about the GATT agreement?
No, madam.
Okay. So you can study the GATT agreements. Okay. On internet you study it. Okay. And tell me about anti-competitive practices. What are the different types of anti-competitive practices? You can search on net and tell me that anti-competitive practices.
Having trade secret. It's one
Trade
of the
secrets.
one of the anti-competitive practices. See, for example, Coca-Cola. The formula for making Coca-Cola is not being disclosed till now.
So anti-competitive practices are the practices which are going towards the monopoly. Okay. So these are the anti-competitive practices. So in that case, why they are inserting these clauses? In the case the license is granted to remedy a practice determined after a judicial or administrative process to be anti-competitive. Okay. So by means of all these judicial and administrative process, if they say that this process is anti-competitive, then what will happen? The license shall be permitted to export the patented product if needed. Okay, so if they give the license, then what will be happen to this practice, anti-competitive practice? It will no more longer the anti-competitive. Okay,
it gets diluted, madam.
It is diluted. Yes. See, that's why they are added this one. Okay.
But this is the same practice also. They also give anti-competitive license, or only in India?
What you are saying?
Madam, this is only in India or abroad also? These anti-competitive practices.
No. For abroad we cannot do. If the patent is granted in India, for that we can do this one.
Ma'am, please explain this again.
Okay, suppose any process by means of any judicial or administrative process, if any patent which is doing the anti-competitive practice, it means the monopoly of that patentee is over that field is there. Then the controller can grant the license or also permit that license to export that product out of India. Okay, to dilute that anti-competitive clause.
Okay.
So next one, section 19(2), that says no license granted by the controller shall authorize the licensee to import the patented article or an article or substance made by patented process from abroad where such importation would, but for such authorization, constitute an infringement of the rights of a patentee. Okay. So which type of license are not granted? That is, the no license granted by the controller shall authorize the licensee to import, shall authorize the license to import the patented article or an article or substance made by the patented process from abroad. Okay. So if the patented article or an article or a substance which is made by a patented process from abroad, and controller cannot grant such license which authorizes the licensee to import such patented article, okay, which is patented at abroad, but for such authorization constitute an infringement of the rights of the patentee. Because why they are not granting that type of license? Because it will create the infringement issue. Okay, that's why they are not granting.
But what about the importing the patented products with the concurrence of the patentee?
With the concurrence of patentee, if the agreement is in that way, if they transfer that technology to so many countries or they want to expand the business, then it is possible.
Okay.
Yeah, but the prior permission is done because they have to notify to the office, patent office, that the license is done in between these two parties.
Okay.
Yes. And if it is good for the territory of that country or within that the limits of that boundaries of that country, then they are permitting. Okay. So they need to notify that the agreement is done in this way. Next one, nothing withstanding anything contained in subsection 2, the central government may, if in its opinion it is necessary so to do in public interest, direct the controller to any time to authorize any license in respect of the patent to import the patented article or an article or substance made by a patented process from abroad, subject to such conditions as it consider necessary to impose relating among other matters to the royalty and other remuneration, if any, payable to the patentee, the quantum of import, the sale price of the imported article, and the period of importation. And thereupon the controller shall give effect to the directions. So it will covered in this this third part, that is nothing, notwithstanding anything contained in subsection 2, the central government may, if in its opinion it is necessary to do so. If the central government permit, then it will happen in the public interest. Okay, so this thing is very important. So when it will done, if the central government will give the permission, and why he will give the such permission, if his opinion in the way that this will create the public interest, then he will direct to the controller to authorize or to give the license in that way. Okay, then it will happen. Okay, please read these 2 points. These 2 points are very important.
So if we understood correctly, the subsection 2 will will disqualify from one being a true or first inventor, right? Yeah. Okay.
Okay. That is the difference between these two. Okay.
Yes.
So
yes.
it will happen only when the public interest is there and the
Yes.
opinion of government in that way. Then it will happen, and he will direct to the controller to authorize that license. Okay.
Yeah. Understood.
Next one, that is special provisions for compulsory license under section 92. So section 92 will cover the special provisions related to compulsory license. In that, what they say that section 92(1), by making notification in official gazette, compulsory license can be granted to any person in following cases. So these are the three important cases by which the controller can grant compulsory license. Okay, so in the case of national emergency, extreme urgency, and third one is the public non-commercial use. National emergency, extreme urgency, and public non-commercial use. Okay, so tell me the difference between national emergency, extreme urgency, and public non-commercial use.
National emergency is pandemic conditions.
Okay. And other, without instead of pandemic, other national emergencies?
Extreme urgency is
Would be in kinds of war situations.
War
situation. Or drought situation.
Yeah, drought also.
Drought situation. In extreme urgency, what we can say the extreme urgency is there? As a situation like COVID or any malaria or any type of typhoid or diseases are occurring in the short period of time, and we are not able to deal with that type of situation, then that situation it is called as extreme urgency situation. A national emergency means the warlike condition or any national or any type of environmental disasters. Okay. And non-commercial, public non-commercial use.
Research institutions.
Yes, for R&D purpose, if the cross licensing, actually cross licensing are done because any technology is based on so many prior technologies, and that's why the cross licensing is done. So in that case, non-commercial.
For research purposes, they are free to use anyhow, right? They don't need a compulsory license.
Yes.
Yeah.
No, but if any technology is recent and another technology which is also going for R&D and which is also essential and which is developed on the basis of this technology which is currently published or currently granted. Okay, then the cross licensing is done between these two parties.
Okay.
Yeah, to get that data.
Okay. Yeah.
Next one, what is 92(1) says by making notification.
But there is still a question striking to me. Public for non-commercial use, which means like nobody will be commercially benefited in that, right? But why do they do this kind of licensing then? But because the person who is getting the license and the person who is giving the license, both will be, if they could not able to commercialize it, then how will they calculate their benefits?
Because in this condition, in this situation, if they are not able to do or commercialize that invention, because some invention are very interesting and they are actually beneficial, but not for this time they are beneficial. So as you know that the metaverse, you know about metaverse.
Yes, I know metaverse. Yeah.
Okay, so if this technology is there, as now, if suppose we don't know about this technology, but still it is developing, na?
Yes.
So after 10 or 15 years, it will going for the commercialization.
Okay,
If any
okay.
R&D will done on that technology or any improvement, then the license will grant on the basis of that for public non-commercial.
Okay, if the technology is not at a matured level, then they can offer a compulsory license on that to make it to get it to.
No, the technology is matured.
Mhm.
But they cannot exploit in the current market situation. They cannot exploit that technology. For the future perspective, it is applicable.
But however, if their patent is getting published, then also they are getting that advantage, right? Without the compulsory license. Why someone need a compulsory license if both of the parties are not able to commercialize the approved technology?
No, there are some details which are not disclosed in even patents. Na? So, so the patent document will not cover all the details actually.
Okay.
So there are some details which are not covered.
But while
So generally,
licensing, one has to disclose those details, right? Or else
yes,
that
yes.
person won't be able
that
to
is
use it.
that is also not mandatory clause, Kashmira. If you see,
How is it?
if you see, compulsory license will be applicable only because even the controller does not know what is beyond this patent, right? And the patent and the person interested may also cannot ask for that. What he can ask is what has been granted. I need a compulsory license for that. But someone cannot ask for your trade secret. See, if you have applied for a patent, if I am your competitor and I saw that you are not launching a product, I can apply for compulsory license and I can get your patent to at least launch my particular product. Because without getting license, I cannot launch my product.
Right.
Okay.
For that,
But
the patent
while you are
has-
giving license, you will just give me your patent rights. You will not disclose your trade secret if something is going behind that patent, right? Because that is your business secret.
Yes.
That's where I'm coming from.
Okay,
But, I
generally
think I
public
will look into details from my end. Yeah, thanks.
So generally public non-commercial use is related to the development of that technology. Okay. And section 92A after Doha, it will added.
Sorry for the interruption, ma'am. If it is taking time, I'm sorry for that. But consider if today most of the people does not have this hydrogen fuel cell battery, whatever they are coming up with, right? So if I look at a patent which is granted and which looks feasible or close to what I am also trying to invent, can I go and ask for this kind of license?
On what basis you want to ask?
Because I have a proven hydrogen fuel cell battery, but I am not able to commercialize it because someone has patented the similar technology, and he has not
but
launched
there
the
are
product.
grounds now. If you are applying for compulsory license,
he has not launched the product yet.
He is not launched the product yet. Okay.
And
but
I will
the
wait for 3
controller
years.
give the
I'm ready
specific
to
time
wait
to
for
that person if the time period is completed for the 3 years, and if your grounds are correct, then you can able to apply. Okay, you can able to apply, but you have to list some grounds, and the term of 3 years of that patent, it will be completed.
Yeah,
Okay.
that is the basic ground for compulsory license, right?
Yes.
But I'm saying, like, when it comes to non-commercial use under this particular provision, it will come only when I show that the geographical conditions are not met or the environmental pollution with the current diesel and petrol vehicles can come into picture, right? So if I put all those clauses, can it still be worth?
If it is in the public interest,
okay,
and you are putting all the clauses, then controller will decide that
yes, and
yeah.
when decision maker is controller, that is for sure.
Yes.
Okay.
So section 92A, capital A, export of patented pharmaceutical products to other countries. So they are saying about the export. Okay. So export of patented pharmaceuticals, that is the drugs to other countries by notification in official gazette of India. So if we want to export any kind of drug which is patented in India, then notification we have to notify to the office. Okay. Notification in official gazette of India, compulsory licensing granted already in that country. Okay. So for that country, the CL is granted. That country by notification allows importation of that product. So also they are also notifying, and we on IP India also we notify that the CL is granted, and in the similar way where it is granted, that country will also notify. Okay, and this will done, that is export will done. So section 92A covers this one, that is the exportation.
Madam, I have one question.
Yes.
Suppose the inventor makes a product in India, in some neighboring country like Bangladesh, after 3 years wants that compulsory license, an applicant from Bangladesh, can he apply for a compulsory license here?
Can you text me that what is your question, because your voice is breaking?
Okay.
Now he is asking if a person from Bangladesh can apply for compulsory license in India. Can he apply?
A person from Bangladesh.
Yes.
Okay.
Can he apply for compulsory license in India?
No, how it is possible?
Is it because of the citizenship, or is it because of the if he has a established assignment in India, then
if he want to establish the assignment in India.
he assume MNCs are there, right? MNCs are there. So now if there is a company who is based out of Denmark, and he has a full-fledged establishment in India also, can he apply compulsory license for patents?
So they want to work that invention in the territory of India and benefit for the Indian citizens.
Indian public, yeah.
Okay. And why they want this type of things? Why they want to benefit the Indian public?
Because they are also playing in India, right?
So
they are based out of any other country, but they are also marketing in India.
Okay.
I think it should not be a problem. I think it should not be a problem until and unless there is an assignment in India. If he does not have any base in India,
no, there are so many agreements actually. They are related to trade and tariffs. So
yes.
there are different types of agreement, and there are different types of MOUs are also there. And TRIPS is also there. So there are different types of provisions of TRIPS also. So they need to study all these, and if they are, it is applicable for what condition or what case they are applying for. It is also seen. So on that basis, they will grant. Otherwise, it will not. So I want to see the one case study. 1 minute.
Ma'am, if you see the last point which you have explained, right? It says that the CL granted already in that country. That country by notification allows importation of that product, which means that if somebody have exported a patent, a pharmaceutical product to a particular country, and if that country tries to give compulsory license in their country to someone else, they have to show the importation of that particular product, right?
Yes.
Okay. Which means,
have you heard about the case of Nepal's case of compulsory license?
No, I at least
Yeah,
from
I
my end,
haven't got that document actually. There is
could you repeat the name?
Nepal's case of compulsory license.
Nepal's case. Just give me some time, please.
In India.
This is Roche versus Natco or what?
Yes.
This Doha style.
Yes.
license.
Yeah. Can you send me the link? I'm not getting that. Paste it into the chat box.
Done, ma'am.
Yeah. Okay. So to understand this one, please read this article. Okay? So in detail, you can understand what exactly they told you and why it is inserted.
Also, I have sent a link here.
Have you got the link?
Yeah, I have got the link and I have shared it also.
Okay. What is the main thing behind that case study? Section 92A, what says export of patented pharmaceutical products to other countries by notification in official gazette of India, compulsory license granted already in that country. Okay, in that country it is granted. That country by notification allows importation of that product. Okay, so if it is granted to that country, then that country with notification can also allow the importation of that product. Okay. So when you study that case study,
Ma'am, are you sharing the PPT or because we could able to see the internet link?
Okay, 1 minute.
I have shared the link. Here, under section 9, under the lens Natco Pharma Limited versus Pfizer/Roche.
Muralidharan, आपका sound, your sound is breaking actually. Okay, you can read it as a homework. You can read and understand that. Okay, so let's see the section 92 capital A of the Patent Act 1970. It is related to compulsory license for export of patented pharmaceutical products in certain exceptional circumstances. So what are that circumstances are there? And it is inserted after the Doha 2001 conference. Okay, so in that you can see the Article 8 of the TRIPS. It is related to public health and nutrition. So when you study that TRIPS agreement, Article 8, then you will understand why they are inserting this clause. In that first exceptional circumstances, the compulsory license shall be available for manufacture and export of patented pharmaceutical products to any country having insufficient or no manufacturing capacity in the pharmaceutical sector for the concerned product to address public health problems, provided compulsory license has been granted by such country or such country has by notification or otherwise allow importation of the patented pharmaceutical products from India. Okay, so the prior case study related to Nepal, it will also shows this one. It will prove that key why it is inserted and why it is related to that Doha and why they inserted this one. Because if any country which doesn't have the capacity to manufacture that type of drug, which is really essential and which can address the main public health problem, then the compulsory licensing was granted. Okay, and the by notification it will done. Okay, by notification they can allow the importation of such product. Okay.
Okay, madam.
Yeah. So next one.
I have shared the link also, madam.
Okay. And then section 92A, what they say, the controller shall, on receipt of an application in the prescribed manner, grant a compulsory license solely for manufacture and export. Solely for manufacturing and export of the concerned pharmaceutical product to such country under such terms and conditions. Okay, under such terms and condition. Okay, if the controller get any application, okay, for manufacturing and export of such pharmaceutical product, then it will happen. Then he will grant. Okay, for such country under such terms and conditions as may be specified and published by him. Third one, the provisions of subsection 1 and 2. So subsection 1, as we know that subsection 1 and subsection 2, the provisions of subsection 1 and 2 shall be without prejudice to the extent to which pharmaceutical products produced under a compulsory license can be exported under any other provisions of this act. So what they explain? For the purpose of this section, pharmaceutical products means any patented product or a product manufactured through a patented process of a pharmaceutical sector needed to address public health problems. So it is also inserted only because they want to address this problem. So only our controller is not considering, or our government is not considering about the public health. It is a universal problems, and that's why this section 92 capital A is inserted. Okay, after that conference. and shall be inclusive of ingredients necessary for their manufacture and diagnostic kits required for their use. So API is also there. So they will give the CL related to active pharmaceutical ingredients for the manufacturing of that type of drugs, or also the diagnostic kits if required, as in the case of you already know that viral infections or other type of infections, the diagnostic kit is required. So in that case, they are granting. Okay. Have you understand these 2 points? These 2 points are very important. Hello.
Yeah, madam.
Yes, ma'am.
Okay. So section 92 in the Patents Act 1970, what they say, special provisions for compulsory licenses on notification by central government. In that first one, if the central government is satisfied in respect of any patent in force in circumstances of national emergency, or in circumstances of extreme urgency, or in case of public non-commercial use, that it is necessary that compulsory licenses should be granted at any time after the sealing, after the grant of patent, after sealing thereof, to work the invention. It may make a declaration to that effect by notification in the official gazette. So they also needed to make the notification before that effect, and thereupon the following provision shall have effects. That is to say, in that subclause 1, the controller shall, on application made at any time after the notification by any person interested, grant to the applicant a license under the patent on such terms and conditions as he thinks fit. So on the terms of public non-commercial use, extreme urgency or national emergency, then if all these provisions are included, then they will grant. In second one, that is in settling the terms and condition of license granted under this section, the controller shall endeavor to secure that articles manufactured under the patent shall be available to the public at the lowest prices, consistent with the patentees driving a reasonable advantage from their patent right. Okay. So also patentee is benefited, and also public is benefited. So this is the mutual benefit.
Yeah, this was the point we discussed, right, last time. When it
yes.
comes to the price matter, we discussed about this thing.
Yes.
Yeah. So the patentee should be derived a reasonable advantage from their patent rights.
Yes.
But if it is going beyond that, then the affordable price has to come down. Otherwise, the compulsory license can be questioned.
Yeah. Yes. So next one, that is the section 92A, to the provisions of section 83, 87, 88, 89 and 90 shall apply in relation to the grant of license under this section as they apply in relation to the grant of license under section 84. So in the same manner, they will apply, that is provisions of section 83, 87, 88, 89, 90 shall apply in the relation to the grant of license under this section in the same relation to the grant under the section 84. Okay. And third one is notwithstanding anything contained in the subsection 2, where the controller is satisfied on consideration of the application referred to in clause 1 of subsection, that it is necessary in the first one, that is circumstances of national emergency or circumstances of extreme urgency, or the case of public non-commercial use, as already we discussed about this. Okay. Which may arises or is required, as the case may be, included public health crisis. It is included after Doha, as we know that, related to acquired immunodeficiency syndrome. It is related to HIV, human immunodeficiency virus, tuberculosis, malaria, or other pandemics. He shall not apply any procedure specified in section 87. Okay. So tell me what is the procedure given in the section 87? what it is told about section 87.
Where the control is satisfied upon consideration of an application under section 84 or section 85, that a prima facie case has been made out for making an order, he shall direct the applicant to serve copies of the application upon the patentee and any other person appearing from the register to be interested in the patent, in respect of which the publication is made, and shall publish the application in the official journal. It is a procedure given in 84, madam.
Okay. So why they are saying here, in the case of in this type of pandemic, he shall not apply any procedure specified in section 87.
Yeah.
Why they are saying that in this case, in under these circumstances, we shall not follow this procedure, which is given
Because
in
it is
section 87.
emergency, madam. Because it is emergency, national emergency. Going through this procedure will delay the availability of the product or the service.
Yes. And for that procedure, how many time will require to get the license through that procedure? Generally, how much time?
It will take more than a year, madam.
Okay. And that's why they are giving the preference to public health and avoided this section 87 procedure. Okay. In relation to that application for grant of license under this section, provided that the controller shall, as soon as may be practicable. So this as soon as, okay, as soon as may be practicable, inform the patentee of a patent relating to the application for such a non-application of section 87. So controller may inform that patentee that he should not apply section 87. Okay. Okay, read this one again.
The provisions of sections 83, 87, 88, 89, and 90 shall apply in relation to the grant of licenses under this section as they apply in relation to the grant of licenses under section 84. Subsection 3, notwithstanding anything contained in subsection 2, where the control is satisfied on consideration of the application referred in clause 1 of subsection 1, that is, it is necessary in the number 1, a circumstance of national emergency, or subsection 2, a circumstance of extreme urgency, or 3, a case of public non-commercial use, which may arise or is required as the case may be, including public health crisis relating to AIDS, acquired immunodeficiency syndrome, and HIV, that is human immunodeficiency virus, TB, tuberculosis, malaria, or other epidemics. He shall not apply any procedure specified in 87 in relation to the application for grant of license under this section, provided that the controller shall, as soon as may be practicable, inform the patentee of the patent relating to the application of such non-application of section 87.
So if you are having a patent related to any pandemic situation can be cured by your patent, then controller will apply you that you should not apply for the section 87. Okay. For that condition.
Madam, normally in these conditions only the government will apply for this, right? Not a normal.
Yeah, government, central government notified to the controller to do that. No? So that is the authority given to the controller. So controller on the behalf of central government do that one.
Okay.
Yeah. Then finally we will going towards TRIPS. So TRIPS is nothing but the trade related aspects of intellectual property rights. So TRIPS provisions for compulsory licensing. So when you study the international arrangements, you can in detail you can see all these type of provisions, TRIPS, and all the treaties, agreements, MOUs. Okay.
That also, madam.
When you study that international arrangement topic, then you will go through all these things, TRIPS and all type of international things. Okay. Related to IP. So we are not going in detail, but just generally for compulsory licensing, these topics are important. That's why I have listed here. In that Article 31F of TRIPS clause caused enactment of Section 92A of Indian Patents Act 1970. Okay, so you can read the Article 31F of TRIPS on internet, and you can understand that. And it will enact the Section 92 capital A of Indian Patents Act. Okay. It deals with the provisions of compulsory license in certain exceptional circumstances, which we already studied in the case of emergency, urgency, and non-commercial use. Then manufacturing and export of pharmaceutical products patented in India to countries with insufficient or no manufacturing capacity. So if very underdeveloped countries there or poor countries are there, and they don't have any manufacturing capacity related to any drug, then manufacturing and export of such pharmaceutical product which are patented in India to that poor country with insufficient or non-manufacturing capacity can be provided, okay, through compulsory licensing. Then the Doha Declaration, what it says, Doha Declaration says that each member has the right to grant compulsory license. Each member means each member country, okay. So each member has a right to grant a compulsory license and freedom to determine the grounds, okay. So it is depend upon the country to country. So CL clauses, CL terms and conditions are depends upon each member country. Okay, so Doha Declaration clarifies that or states that each member country has the right to grant the compulsory license, and also he is having the freedom to determine the grounds for that compulsory license. Okay, then the patentee is not giving opportunity to present arguments. Okay, so why patent is not given the opportunity to present the arguments? Because there is the condition like a national emergency, extreme urgency. So in that condition, they will not give any opportunity to the patentee. So it is for the public benefit, and in the crisis situation, they are doing this one. Okay, so you can also read the Article 8 of TRIPS agreement on internet, then you will understand in detail. Okay, so that's it. In today's class we studied about compulsory licensing, and in the next lecture we will go through all the other details related to compulsory licensing.
Thank you,
Yes,
madam.
any questions? Yeah.
No questions, ma'am. Thanks for the detailed.
We had a lot of questions during our session itself, like debate and other things. It was a useful session.
Okay. Oh, 1 minute. There are 2 slides remaining. That is related to termination of compulsory licenses. So I will cover this within 5 to 10 minutes. Okay.
Sure,
Okay,
sure.
madam.
Okay, yeah. The termination of compulsory license, section 94. It will gives that provisions related to termination. Okay. So what it says, if patentee makes an application for termination, so who will make the application for termination? That is the patentee.
Patentee, madam.
Yeah,
Patentee.
if patentee makes an application for termination, controller can terminate that license. Okay, if reason for granting that license is no longer exist. So on what basis controller give the license to another person? If that reason is no longer exist, then controller can terminate that license if the notification is if the application is done by the patentee. Okay. Next one, termination should not be appealed on unnecessary grounds. So if the termination is done on the basis of unnecessary grounds, then it will not happen. Third one, the holder of license can object the decision of controller. Even the licensee have that power to object the decision of controller. Okay. So these are the three grounds on which the compulsory license is terminated. Next, you can see section 94, termination of compulsory license in that first and second on an application made by the patentee or any other person. So even patentee or any other person deriving the title or interest in the patent. So the applicant or other shareholders, if they are having the shares in the patent, they can also apply. Okay, interest in the patent. A compulsory license granted under section 84 may be terminated by the controller if and when the circumstances have gave rise to the grant thereof no longer exist and such circumstances are unlikely to recur, provided that the holder of the compulsory license shall have the right to object to such termination. So what we studied earlier, that is given in this one. Okay, what you understand by this first one, 94 clause 1?
That means the national emergency, see, the patent was granted, compulsory license was granted under 3 conditions. That is, it is not worked in India, and the product is not available to the public at affordable price, and there is a national emergency. See, if these 3 conditions do not exist, then the patentee can approach the controller by proper application that compulsory license can be revoked.
Okay. Okay, and the other grounds? If suppose a patentee, if a controller granted the license to ABC, okay, and ABC is not able to do or work that invention in the territory of India. So is it possible to terminate that compulsory license, or is a patentee can apply for the termination?
Yes, of course, madam. Yes.
Yeah.
Because not a competent person, that the compulsory license holder is not a competent person to manufacture as per the applications, then the patentee can approach controller to revoke it.
Okay, yeah. Okay. Second one, while considering an application under section 1, the controller shall take into account that the interest of the person who had previously been granted the license is not unduly prejudiced. So what is the meaning of not unduly prejudiced?
That means it's not overlooked, madam. That is, the rights of the patentee is not overlooked.
Or the licensee is not taking undue advantage of.
Yeah, that is. Yes.
Okay, yeah, that's right. That I told in other way.
Yeah,
Okay.
from patentee's perspective.
Yeah.
From patentee perspective.
So that is for today's topic. In the next class, we will discuss the more sections. Okay.
Okay, madam. Okay.
Yeah.
Thank you, madam. It was a very nice session.
Thank you, ma'am.
Thank you. Bye.
Thank you, ma'am.